Good afternoon, everyone. Apologies for starting late. My name is Barbara Olshansky. I am a human rights person here at University of Maryland. This issue is very important to me. We have been working as part of the clinic where I bring students for a semester to Namibia, Southern Africa. We've been working on the human rights of water for some time. So I think this is a very exciting panel with some great experts, and we'll start right away so that we can make sure everyone has time to speak. The first speaker is Jimena Maria, and she graduated as a lawyer from the Externado University of Colombia in 2005. Before doing her master's in Belgium, she worked at Pisa and Caballeros Consultores Limited and the Superior Tribunal in Colombia. She gained practical experience in the diverse issues of tax and labor law. Then she moved to London, where she took a course on legal methods at the University of London. In 2008, she obtained her Advanced Masters of European and International Energy and Environmental Law at the Catholic University of Leuven. And she is now also, as if she doesn't have enough degrees, so she's working on her PhD on the human right to water. Please join me in welcoming her and hearing what she has to say about this important issue.
Good afternoon, everyone, and thanks for coming here. As we all know, water is an essential element for life, and this is the reason why we should try to guarantee access to water to everyone in the world. In order to do so, we are trying to look for different ways to protect the right to access water. And today, what I want to do is to analyze whether the right to a healthy environment can contribute in the achievement of the right to water. And I will look into the case of Colombia. I will just talk about a little bit the relationship between sustainable development and water. Then I will talk about the human right to access safe water, move into the right to a healthy environment, and I will focus on the case of Colombia, and I will come up with some conclusions. So sustainable development, we talk about it more or less since 1992 for the United Nations Conference on Environmental Development, and we say that it's composed of mainly three pillars, which are economic development, social development, and environmental protection. As we all know, these three pillars were put together because we realized that economic growth will affect other areas important for human survival. So we have that. We have a specific point of connection between the human well-being and also human rights and environmental protection. And then we found the human right to a healthy environment plays an important role by protecting certain natural resources, but at the same time, certain human rights. So we all know that if we're going to focus now in the pillar of the social development. And it can be seen that in all programs, commitments, or documents of the sustainable developments talk about one specific topic or one common element, which is access to drinking water. And we can see that, for instance, in Agenda 21, which was adopted in 1992, in which in the chapter 18 talks about a general objective to make certain that adequate supplies of water of good quality are maintained for the entire population of this planet. Then in 2000, with the Millennium Declaration, world leaders meet together to agree to eradicate poverty. And they decided to adopt 8 goals and 18 targets. As part of these goals, goal number 7, talk about how by 2015, the proportion of people without access to drinking water. And then in 2002, in the Johannesburg Summit, this commitment was reaffirmed in the Johannesburg Action Plan. But what we ask here is why so much emphasis about bringing access to water to the whole population when we are actually surrounded by an abundant amount of water? And the answer is very simple. 97% of the world water in the world is salt water. And normally we focus in all our human activities in fresh water. which is only 2.5% of the world water. But out of that 2.5%, only 0.3% consists or is storage in the lakes and rivers. So the rest of the water is difficult to access because we can find it in soil moisture, glaciers, and snow. So we found that water has become a common denominator in all challenges of sustainable development. We use water for energy production, industrial activities, food production, poverty eradication, as well as human consumption. So we realized there is a competing uses for the resource, and that the demand for the resource is increasing every day more and more, especially for population growth. And it's linked between all the activities, because then we need more water to produce more for the population, more water to produce more energy for the population. So the demand for water will increase every day more and more. As a result, we have a kind of worry situation because we are creating a water crisis, or we can see now a water crisis. So what we see now is the new emerging of a human right, and now we're talking about the emerging right of the emerging right of the human, or the right of human, the emerging right of access to safe water. But what that means, according to General Comment 15, we say the access to safe water entitled everyone to sufficient, safe, acceptable, physically accessible and affordable water for personal and domestic uses. So we know that this human right to water only guarantees right for personal and domestic uses, meaning for drinking purposes, cooking, sanitation, personal and household hygiene. We also know that water must be safe, which means it has to be free from microorganisms, chemical substances, and radiological hazards that constitute a threat to health. It is important to realize that in order to protect the right to access water, the resources itself has to be protected. And a way to do that is to protect the right from pollution and overexploitation. These two circumstances generate problems with access to water, availability of the resource, and for instance, pollution. Although it doesn't really reduce the availability of the resource, it makes that it's contaminated and it creates risks for human health. So it's impossible to use water for human consumption when this one is polluted. So what is going on with the right to access water? We have a problem because this right has not been universally recognized, which means it is not possible to enforce it. So what is the solution that I'm trying to find out here? Is to use existing human rights in order to protect the right to access water. From a human rights perspective, we know that all human rights somehow are interconnected. So for instance, the right to access water are already connected to the right to life because humans need a minimum intake or daily intake of water in order to survive. We also know that access to water is related to the right to food because it's important for food production as well as for cooking. It is also related to health because if we don't drink the enough amount of water we need, we're going to suffer some illness, and it's the same if the quality of the water is not good, then it's not going to be for our health. And lately, according to the General Comment 15, it's also related to the adequate standard of living. So I believe there might be an extra human right to cooperate in the protection of the right to access water. And I believe the right to a healthy environment can indeed help us to protect this right, because it will help us to protect the resource itself, meaning to try to avoid pollution or overexploitation. The right to a healthy environment is understood as the right to live in an environment of quality that permits a life of dignity and well-being. This right tries to protect the different natural elements, such as the soil, the air, the water. It's also try to reduce and prevent pollution, such as noise and visual contamination. The right to a healthy environment has been recognized in the resolution of the General Assembly of the United Nations, the Resolution 4594, in which it says that all individuals are entitled to live in an environment adequate for their life and well-being. Likewise, this right to a healthy environment has been recognized at the regional level, for instance, in the San Salvador Protocol adopted in the Inter-American System of Human Rights, and it has been also recognized in different constitutions around the world, such as in Colombia, in Argentina, in Bolivia, in South Africa, and a lot of countries in Africa continent. So now I'm going to focus to see what is the actual situation of Colombia and how we can really see in practice whether this right to a healthy environment can help us to contribute in the protection of the right to access to water. What we have now is the actual constitution of Colombia. It was adopted in 1991, and it has a non-exhaustive list of human rights. And it listed, for instance, civil and economic rights, civil and political rights, economic, social, and cultural rights, as well as collective rights. The Constitution itself differentiates different judicial actions according to the human rights. And it says there is a list of fundamental rights, such as the right to life, to health, not torture, that has to be protected by a specific action, which is called tutela action. This action is a priority action, is a summary action, and the idea is to claim the protection of this right when it has been affected or is threatened to be affected by an action or omission of the public authority. The last instance of this tutela action is being analyzed by the Constitutional Court. The Constitution also established that in order to analyze or protect collective rights, such as the right to peace, public health, space, and the right to a healthy environment, there are specific judicial action, which is the popular action. This action can be initiated in order to protect the breach of collective right or the potential breach of a collective right of an action or an omission of a public authorities or of individuals, which is a big difference with the tutela action. The last instance of this popular action is being analyzed by the Council of State. And then we have a third situation, which is being given by the jurisprudence of the Constitutional Court, in which authorizes that the right to a healthy environment can be protected also through tutela, although we already established that it's a collective right, only if all fundamental rights are also affected. So what is the actual situation in Colombia? So the right to a healthy environment has been explicitly recognized in the Constitution. However, the right to access water is not recognized, although we have a non-exhaustive list of human rights. So indirectly, it could be as understood as a non-enumerated right, but when we have to really decide that in front of the court, and it's very difficult. So what I'm going to do now is I'm going to try to see different popular actions and tutela actions to see whether in practice the right to a healthy environment is really contributing or not to the protection of the right to water. So the first popular action, we have the plaintiff was alleging that for more than 20 years the village of Fortalecillos has been supplied with contaminated water. The situation was that the water taken for the water supply, it was taken from a water channel that it was polluted with pesticides coming from rice plantations, but also with the discharge of sewage system for other villages nearby. So what was happening, it was that water was taken from the channels and really provided to the homes without being treated. So it was understood the water was not suitable for human consumption. The Council of State analyzed the situation and decided to grant the protection of the right to a healthy environment and access to public service, in this case, the service of potable water. As part of the popular action, the court has the possibility to give specific orders to the defendant in order to protect the right. So in this case, the Council of the State decided to order the municipality to take the necessary measures to guarantee potable water for the inhabitants of the city, and it ordered also that it has before the discharge of the sewage system of the nearest villages has to be treated before it was dumped into the river. It also ordered to protect the biodiversity of the river because it considers that it might influence also the inhabitants of the surrounding of the inhabitants of the city. So it is very clear that in this situation, through the protection of the right to a healthy environment, we are actually protecting the right to access water, since after all this cleaning up, the inhabitants of Fortalecillos are going to receive clear potable water. We have a second popular action, and in this case, it was claiming that due to an omission of some works, the sewage system was leaking into a river, producing again contamination. The other point that it was making a little bit more worried citizens is that the river called River San Jose, it was flowing through another river. And from this second river, the water was taken to use as a potable water for the supply of a neighbor village. In addition, during the procedure, it was proven that the population living along the river, it was discharging all the waste from the household into the river, increasing the pollution of the resource. As a conclusion, the Council of State decided to, again, grant the protection of the right to a healthy environment, and it ordered the municipality to clean the river, invest resources in potable water, because it was also a problem that the water was not chlorinated before sent it to homes. So it was a really problem for water not able for consumption. And it also ordered to start educational programs for the people living along the river to tell them the importance of not contaminating the water with the waste, household waste into the river, and just send it into the proper place. In this case, protecting the resource and avoiding more contamination. So I'm going to move to a tutela action in this case. The plaintiff was alleging the protection of the right to life, dignified life, right to health, and a healthy environment. As I mentioned before, in order to initiate a tutela action for the protection of the right to a healthy environment, other fundamental rights needs to be also affected. So in this case, right to life, dignified life, and a right to health. The problem here was not really the contamination of the river, but it's actually the municipal service of the city was providing contaminated water into the city of the homes of the inhabitants of the city. It was alleged that the water was physically, chemical, biological, not apt for human consumption. Although during the proceeding it was proved that the water was physical and chemical apt for human consumption, but it was not bacteriologically apt for human consumption. It was actually full of chloroforms and fecal matter. So that's why people was getting very sick. The court states, the Constitutional Court in this case, states that the supply of polluted water that is not acceptable for human consumption constitute a risk and a violation of the fundamental right to life, dignified life, and a healthy environment. So it granted the protection of all the rights, and in a certain way, it decided to protect also the right to access water through other rights. The Constitutional Court in other cases has been very clear to say that without water, there is no life. And it has also mentioned in different cases that the actually supply of water, it doesn't really mean to supply the liquid to homes, but it has to be a supply of safe water up for human consumption. It has also said this because it explained that the water supply for home is just given to meet the basic human needs of people. In other tutela action cases, it has said that drinking water constitutes a fundamental right that is part of the core elements of the right to dignified life when intended for human consumptions. So we can see that in different cases, the Constitutional Court has actually protected the right to access to water, but indirectly through other human rights. So it is very clear, I will come up with my conclusions, that in fact, the right to a healthy environment, whether through the protection of the popular actions or the tutela, do contribute in the protection of the resources, or water resources, and also in the achievement of the right to access water. We can also conclude the Constitutional Court has acknowledged or recognized that the access to water is part of the core elements of other human rights, and it has said that the water supply to homes might be safe for human consumption. I would like to thank you for listening to my presentation.
I think we'll save time for questions at the end. We're going to hear now from Professor Loretta Ferris. Professor Ferris holds a bachelor's in law, an LLB, and an LLD from the University of Stellenbosch in South Africa, and an LLM from Georgetown University here. She is a professor of law in the Institute of Marine and Environmental Law and teaches natural resources law, pollution law, and international environmental law. Prior to that, she was an associate professor at the University of Pretoria, where she was also a research associate at the Center for Human Rights. She has quite a long history in academia and a very long list of selected publications on, I think, things that are of interest to everyone. And I think what I'll do is I'll leave people's CVs afterwards so you can see what they've written on and think about whether you'd like to try and get copies of those publications. So join me in welcoming Professor Ferris.
Thank you for that introduction, and good afternoon, everybody. So, I'm going to speak about that which we normally do not want to speak about in polite conversation. And I'd like to start with this quote that the disposal of human waste is a subject normally buried in euphemism and avoidance, at least in public. Privately, on the other hand, every single person on the planet is intimately concerned on a day-to-day, even hour-to-hour basis with the need to relieve themselves in a congenial place and fashion. The physiological necessity of excretion cannot be averted, even if it cannot be spoken of. So, it is something that is natural to us. But it is not necessarily always accessible to everyone. But I'm going to talk about specifically of the emergence of this right to sanitation, which is sort of over the last really sort of 2 years has gained prominence as part of the right to livelihood, which is predominantly socioeconomic in nature, and which is connected to the right to water. And I'll just briefly allude to the history of sanitation and the whole notion of sustainable sanitation, which is what we're moving towards. And then I'm going to connect the issue of sanitation to human rights, because we are talking about a right to sanitation. But most importantly, I'm going to critique this emerging right from an environmental perspective, as it seems, if you look at all the documents, that all of this is done outside of an environmental context. And I'm going to point out what is problematic of this approach. So the whole issue of sanitation has been around for a very long time. So if you look at sort of what archaeologists have found, they'll see that in 1867 BC, residents of ancient Babylon already had indoor toilets connected to a very rudimentary sewer system. Similarly, the peoples of Egypt, Crete, and Rome. What was important is that these kinds of sewer systems were essentially waterless, basically pit latrines utilizing sand. Western world, on the other hand, took a bit longer to actually get to sanitation systems or human waste disposal systems, and required health threats such as cholera, which became quite a problem around the 1800s. And also just the discomfort around a lack of a waste disposal system. For example, the Great Stink of 1858 in London, which led to the closure of the Parliament for quite a few days, and directly led to them actually mandating the establishment of a sewer system. So this was quite late if you compare it to the other civilizations. The difference between the human waste disposal system that came with, or that sort of was part of the West's perception of sanitation is primarily waterborne. And we've also seen with it the birth of the flush toilet. Now, this waterborne sewage notion spread through colonization to other countries and those countries that were colonized. And one of the issues that I'm questioning is the appropriateness of waterborne sanitation, because I think it ignores a whole number of issues, such as, for example, whether waterborne sewage is necessarily environmentally appropriate. For example, in water-scarce countries, or whether it's economically appropriate in very poor countries, or whether it's socially and culturally appropriate for example, in countries where women, due to their status, are unable to utilize these systems. So today, we have a fascination with the toilet. And that is our primary system of human waste disposal. And it's a toilet that utilizes lots of water, especially in the US. And we have glorified the toilet, and it comes in all forms and shapes. However, on the other hand, 2.6 billion people around the world lack adequate sanitation. 1 billion has no access at all. So this fascination with a flush toilet is only limited to about 30% of the world population. 1.8 million people die every year of diarrheal diseases, of which 90% are children under 5. So there's an over-reliance, as I already said, on waterborne sewage. There's lack of sustainable water supply in many of these countries where there are no access or limited access. There are problems with regards to establishing and setting up wastewater treatment works. Primarily because sewage systems and treatment plants are expensive to set up, they're expensive to maintain, they're expensive to upgrade. And so even in countries where there's no water scarcity, often there is no sanitation because of the economic cost that's related to it. And then just really, when you think about it, what are we really doing? We are using potable water, which is often very scarce in some countries, to flush away human excreta. So there is a movement, and this is coming primarily from the side of engineers, and there seems to be a disconnect between what engineers are doing on the ground and what the United Nations is professing. So we have this movement towards alternative sanitation, especially in the developing world, and it's a focus that is on sustainable sanitation systems. For example, there's great reliance these days on grey water systems, on dry methods, for example, urine diverting systems. And there's also a focus on what are the cost-benefit analysis of this. And the studies have shown that it's actually more cost-effective. And there are also, in addition, other socioeconomic benefits or financial benefits, such as spin-off ventures from the kind of dry methods where you utilize the urine in urine, for example, to create fertilizer. For example, somebody told me that in South Africa, we have quite a large fertilizer industry. And they, in order to make fertilizer, import urine containing urine from China. Why is sanitation a human rights issue? Clearly, the inability to access sanitation services in privacy, such as, for example, the way millions of people do around the world, impacts on your right to dignity. It impacts on your right to equality. For example, in some cultures, women are not allowed to utilize public facilities. So they wait until nightfall before they go and release themselves. And that, of course, brings other threats to mind. The threat of being attacked, the threat of being raped, etc. And when you think about the fact that it's really the poorest of the poor that has to sort of deal with this right to dignity issues, we have sort of in South Africa, in our constitutional jurisprudence, come up with this concept of equality of dignity. Basically talking to the fact that when you have disproportionate socioeconomic status of people in a country, you have an inequality of dignity, which compounds the fact that you are infringing on the right to dignity and to equality. The right to bodily integrity and the right to life specifically dealing with the issues, the threats to health coming from waterborne diseases. The right to health is impacted, and of course the right to water, as you need to in those countries that have a heavy reliance on waterborne sewage, it impacts their right to water. But also, the way in which all of this has been addressed is a right to water as a socio-economic right and not necessarily as an environmental right, as Jimena has just pointed out. The right to housing is impacted in South Africa in our constitutional courts. They have interpreted the right to sanitation as part of the right to housing. And so if you do not have access to adequate sanitation, it impacts on your right to access housing. And then the right to education, for example, girls that are not able to go to school because of the inadequate provision of sanitation. And then the right to a healthy environment. But this, all of the bubbles in red and blue, these have been documented by scholars, by the UN, reports, guidelines, etc. But the right to a healthy environment has not been flushed out. So right now what we have is only two explicit references to a right to sanitation, and those are contained in CEDAW as well as in the Convention on the Rights of the Child, both of which have very clear socio-economic dimensions. Then in July 2010, the UN General Assembly for the first time recognized a right to sanitation. That was followed by a Human Rights Council resolution where they gave content to this right to sanitation, and they said the right is a right to safe and clean drinking water and sanitation as a human right that is essential for the full enjoyment of life and all human rights. And that's derived from Article 11, which guarantees the right to livelihood. Right to livelihood has been associated with food, with clothing, with education, all rights with very clear, once again, socio-economic dimensions. So, prior to 2010, there were quite a number of documents starting sort of around the mid-1990s where the UN started to look at what is this notion of what is rights, what is the right to water and sanitation. There were reports, there were guidelines that eventually led to the appointment of a special rapporteur in 2008. At that point, she was basically an independent expert on the right to water and sanitation. She then fleshed out what is this right to water and sanitation. And so her mandate was to do that, to clarify the content of human rights obligation in relation to access to safe drinking water and sanitation. She defined sanitation as a system for the collection, transportation, treatment, and disposal or reuse of human excreta and associated hygiene, and she very specifically acknowledges the interconnectedness with other human rights, and she specifically focused, especially in her early documents, on the right to dignity and how a lack of sanitation or lack of adequate sanitation profoundly impacts on dignity. And she made this argument that because of that, it actually should be a freestanding right. But she wasn't very successful in that argument. And so she sort of then linked the right to water as the right to water and sanitation. And the rationale for this link is that waterborne sewage systems are common in many parts of the world, and without proper sanitation, human excreta contaminate drinking water sources, affecting water quality and leading to disastrous health consequences. Now, I can see that link from a water perspective, but from a sanitation perspective, I have to criticize that because of the fact that waterborne sewage systems may be common, but they may not necessarily be appropriate in most countries around the world. And so I'm sort of concerned that because of this link, it may actually hamper the work of engineers, etc., who's trying to look at more sustainable sanitation systems. And just come out with a number of criteria for this right. And I'm not going to go through each and every one of them, but what strikes me is, once again, that this right is conceptualized without any connection to the environment, to what sanitation can do to the environment, what sanitation can actually, the impact of sanitation on water. I mean, Jimena has just mentioned the kind of pollution that stems from sewage disposal and how it fundamentally impacts on the quality of water and the safety, not only for humans, but also for, of course, ecosystems. My argument is that this is a flawed conception. Any acknowledgement of the role of the environment, the role of, or just an acknowledgement that water is part of an ecosystem is completely absent. The consequences of sanitation for the environment has never been mentioned. It's conceptualized as a socio-economic right, as part of the right to livelihood. And I will point out what are the problematic nature of conceptualizing it as a socio-economic right. Once again, it's interpreted as connected to water, but not as water from an environmental perspective, but water as a socio-economic guarantee. As I said, the connection to water is done from a socio-economic perspective, and it completely ignores water as an ecosystem. And it also completely ignores sustainability requirements, such as, for example, the availability of water, or where water exists, the inadequacy of supply systems. It doesn't talk about the affordability of water or the affordability of setting up treatment systems, or the affordability of maintaining those systems or reinvesting in the infrastructure, etc. And then it also does not necessarily, it talks about the culture from a dignity perspective, but not necessarily from an environmental perspective. One of the biggest problems for me in terms of its conceptualization of the status as, of the right as a socio-economic right, is the fact that socio-economic rights has a very particular way of being interpreted. We know that there are these different generations of rights: first generation rights, second generation rights, third generation rights, and of course socio-economic rights are second generation rights and have been interpreted the group of rights have been interpreted in a very particular way. For example, both in their phrasing, if you look at documentation, international documentation, for example, the International Covenant on Socio-Economic Rights, if you look at South Africa's constitution, is one of few constitutions that actually have socio-economic rights in the constitution. There will always be, in the phrasing of the right, a limitation in terms of availability of financial means of the state, because in order for a state to provide access to socio-economic rights, they have to make substantial financial investment. And so therefore, this is limited to their financial means. If you look at environmental situations, for example, so let's say, for example, you have pollution of a water resource. Whether, typically, let's think of the oil spill, the BP oil spill. There's no question as to whether there are financial means to actually address that spill. Because of the threat to the environment, you have to dispense your budget to actually clean up. And that's the difference in terms of an environmental right and a socio-economic right. And there's also, coupled with that, the whole notion of progressive realization, that there is no immediate demand on a state to actually spend the money to give access to a right. Whereas from an environmental perspective, progressive realization is not always viable. So when you have sanitation as a socio-economic right, absent from an environmental context, it means that you can rely on limitations such as financial means and progressive realization. The other difficulty that's not necessarily embedded in socioeconomic language but comes up in the interpretation is the whole notion of a core minimum content. That's the idea that every socioeconomic right has a minimum basis for fulfillment, and that should at least be fulfilled. So, for example, with water, the World Health Organization has come up with a specific amount that the person needs per day to sustain themselves. That is not always environmentally viable. For example, in a country such as mine, where there is severe water scarcity and droughts at times, this may not necessarily always be feasible, and that was recognized, for example, in a constitutional court case. And so when you look at the notion of core minimum content, whilst it is understandable in terms of trying to guarantee a socio-economic right, it's not always viable from an environmental perspective. So the ideal is to have a right to sanitation that embeds the notion of sustainability. And here I'd like to refer to a model that was sort of the brainchild of Willemien du Plessis' husband, Johan Nel. He sort of looks at sustainability not from a pillar approach, but more from an embeddedness approach, where he situates what we normally understand to be the pillars within the overall framework of governance, because all of this needs to be regulated from a governance perspective. But very importantly is where he places environment and the acknowledgement that everything that we do, whether we're dealing with the cultural or the socioeconomic, it is dependent on the environment. So socioeconomic pillars and cultural pillars are all embedded in the environment. Of course, he brings in the cultural, and I think from my explanation about the issues, the cultural issues that comes up, it is a very appropriate aspect of sustainability that needs to be recognized. And so really what one would like is a right to sustainable sanitation that brings, that acknowledges that at the basis of sanitation is the environment. And that you have to provide for a right that, whether it's waterborne or not, has as an ideal ecological sustainability. That also looks into socioeconomic aspects, making it affordable, etc., as such as the rapporteur has sort of pointed out, and then also looks at the cultural aspect thereof. So ideally, of course, the first prize for me, and this is in conclusion, is to have a standalone right to sustainable sanitation. But knowing how the UN works, we know that that's not going to be possible. So for me, what I would really like to see is a reinterpretation of the right. First of all, that's divorced from water as the only way to give effect to the right. I'm not saying do not acknowledge waterborne sewage systems, because they are with us, and they'll probably be with us for the next 200 years. But acknowledge that you can provide access to sanitation without water. And then also bring into play the sustainability requirements, which includes an acknowledgement of the centrality of environment, whether with water or without water, when it comes to sanitation. Thank you.
So our next and last speaker for today is Professor Michael Kidd, who is currently the Deputy Dean in the Faculty of Law at the University of KwaZulu-Natal in South Africa. Professor Kidd holds an LLB, an LLM, and a PhD, all from that university, and he initiated the environmental law program, both at the LLB level and the LLM level, at KwaZulu-Natal, and has been teaching in these programs since 1992. My guess is that he says that he supervised many students from all over Africa. My guess is many during those years, and has published widely in regard to matters relating to compliance and enforcement. So there's textbooks by him, many articles as well, and I'm hoping that everyone will give us either websites or email addresses, so we'll be able to access all of their publications. Please join me in welcoming Professor Michael Kidd.
Afternoon, everybody. I'm not entirely sure that the title that you have here is exactly what I'm going to talk about, but I suppose like many people, I thought that's a good idea, send in the title when I got to write the paper. It didn't quite turn out like that, but it's certainly dealt with. But what I'm going to be looking at relatively briefly is the water aspects of the Rio +20 outcome document. And then looking at it not only in the context of the right to water in South Africa, but really at the interface of the right to water, the right to equality, and the right to food, and issues of food security. Not that those are the only relevant rights in the context of this particular discussion. Of necessity, because of time constraints, I'm going to have to go through some of this stuff really relatively quickly, but obviously would be delighted to look at this in more detail with anybody who wants to discuss it with me later on. This, as we heard this morning, was the outcome of Rio +20, or perhaps one of the outcomes, the future we want, the official document that came out of the discussions. This particular aspect, more of the general outcome or the central theme rather than the specific issues relating to water. But I think the issues here are really relevant to the water aspects that are dealt with in that outcome document. The central theme, particularly important in the context of a country like South Africa and indeed many other developing countries, this notion of the green economy in the context of sustainable development and poverty eradication, which I think are very important themes in the context of what I'm going to be talking about this afternoon. The aspects relating to water and sanitation dealt with under the general heading of thematic areas and cross-sectoral issues. I'm not going to go through these in detail. These are the particular paragraphs, 119 to 124, those of you who haven't seen the document yet. If I were to summarize the key issues that come out of the water aspects, water is a key to sustainable development, I think a fairly obvious conclusion. Emphasis of integrated water resources management, IWRM, sustainable water use. Progressive realization of access to drinking water and sanitation. Progressive realization of the right to safe drinking water, not entirely sure what the difference is between those two aspects. To protect and manage ecosystems, to maintain water quantity and quality, balance supply and demand, and reduce water pollution and improve quality. And what I'd like you to think about is these particular key issues and how they are addressed in the context of South African water law and policy, which is what I'm going to be looking at next. And one of the issues that hopefully will be apparent from my discussion of these aspects is the problem which has been identified in many contexts and has already been mentioned several times today, the problem of implementing the law on paper. And you'll see that there are various implementation challenges in respect to water law and policy in South Africa from what I'll be looking at, and in particular, one particular relatively small case study that illustrates some of these issues. Very briefly, in oversight, significant numbers without access to water and sanitation in South Africa. There has been positive impact on these figures since 1994 when the new government came into power, but there's still significant numbers who haven't got access to these resources. And as Loretta indicated earlier on, there's significant parts of the country where there are severe water shortages and even water stress, and this is likely to be exacerbated into the near future, where most of the economic centres in the country are going to be short of water within about 10 to 15 years. Overall, South Africa is a semi-arid country. Water use in South Africa, official statistics in 2000, I'm sure that there's not any significant difference between 2000 and now in the context of the water usage. We'll see there significant player is agriculture, 62%. The figure for urban includes both industry within urban areas as well as domestic use. As far as law and policy is concerned, we start with the Constitution, Section 9, the right to equality, which also includes provision for redress of past inequality. So not only is there a right to equality, but the Constitution provides for what you might call transformation, or which is called transformation in our country, or equity, or in many other countries what would be referred to as affirmative action. Section 27 provides that everyone has the right to have access to sufficient food and water. This is to be progressively realized on the basis of available resources. So it's recognized that these rights cannot be provided overnight. Very broadly, The policy dimensions, and this isn't necessarily a closed list within which water management takes place in the country, what is often referred to as BEE, altogether with its sting or not, depending on the perspective you might have. Broad-based black economic empowerment, poverty alleviation, and economic development in order to address poverty alleviation. Sustainable, sometimes in that phrase, more than often not. Sustainable development as required both by Section 24 of the Constitution and important environmental legislation in the country. Obviously, food security is important. Access to water and sanitation, as Loretta was indicating earlier on. Land reform, particularly more black ownership of land, is an important policy dimension, as well as the protection and management of ecosystems. As far as specific water legislation is concerned, just to highlight some of the aspects of the law, in terms of the Water Services Act, the law, as recognized by the Constitutional Court, has provided that basic human needs require 25 litres per person per day, which I think is somewhat less than the World Health Organization ideal, which I think is about 30, isn't it? 16. So, and this is provided free in many areas where it's possible to do so. In terms of the National Water Act, the Act is aimed at integrated water resources management broadly, and it has an important provision in it which is fairly innovative as far as water law internationally is concerned, and that's protection of the ecosystem, particularly aquatic ecosystems, by means of a principle called the reserve. The reserve then is the amount of water that is necessary, both from a point of view of quantity and quality, to satisfy basic human needs, which, as I indicated earlier, being recognized legislatively as 25 litres per person per day, and the amount of water that's required to protect aquatic ecosystems taken together. The idea is that when one looks at a particular amount of water in a catchment, that once the reserve has been determined, whatever else is left after the reserve has been determined is the amount of water that can be allocated for other needs, including agriculture. Water use, in terms of the National Water Act, requires a license, except in certain quite broad exceptions. And one of the exceptions is the so-called existing water use. Existing lawful water use. So at the time that the Act came into effect, if the water use that you were carrying on was lawful for 2 years prior to the date on which the Act came into effect, that can continue indefinitely until such time as decisions are made in terms of the Act for that regime to change. So what one finds is that in 1999, when the Act came into effect, there were significant lawful water uses carried out by white farmers, who are still exercising those water rights more than 10 years after the Act came into effect without having had to change. What the Act does envisage, though, is a situation of compulsory licensing. So where people are still carrying out water use on the basis of the existing lawful use, it might be necessary at some stage for the authorities to decide that they have to then get a license. And the reasons for compulsory licensing are set out there in Section 43. Two of the main reasons, as one perhaps might expect, a situation where there isn't enough water to go around, so where the water dynamics require changes in water use. So if a person at the moment is using, in terms of an existing lawful water use, 100,000 cubic meters per year, it might be necessary to reduce that because the amount of water that's available in that catchment isn't enough. But also importantly, in the context of what I'm going to be talking about, one of the other reasons for compulsory water licensing is when it's necessary to review prevailing water use to achieve equity in allocations. Compulsory licensing hierarchy envisages allocating water on the basis of the following. Firstly, the amount of water that's required for the reserve, which I spoke about earlier. Secondly, what water is needed for international obligations in terms of shared water resources. The requirements of existing licenses, any new licenses that are aimed at providing for equity or transformation, any other new licenses, so when somebody applies for a license but they essentially are not black, and then existing lawful water uses. And these are the considerations that have to be taken into account when any license is granted, either in terms of compulsory licensing regime or in an unsolicited license situation. Take note particularly there of subsection B, one of the purposes for which licensing is to take place, one of the factors to be taken into account is the need to redress the results of past racial and gender discrimination. Water policy, one of the important aspects of water policy is strategy for water allocation reform, which is focused very much on reform of the racial ownership, if you want, of water rights. And in terms of this particular policy, the targets, that table 2.1, national targets for water allocation, doesn't specifically indicate in the title, but that is the target for black holding of water rights or water licenses, 60% by 2024, and then in respect of women, 50% by 2024. And that is very different from the situation as it is at the moment. I'm going to give you a very brief case study that demonstrates some of the problems that arise in implementation both of the law and various policy dimensions that I mentioned. This is the Tosca Molopo compulsory licensing process. Why I've dug this particular case study out is that it's the first compulsory licensing process that has been completed in terms of the National Water Act. The area that you're looking at is pretty much the area in that circle, which is, as you'll see there, pretty much on the border of South Africa and Botswana to the north. It's pretty much scrubland, not very significantly inhabited, and I think most people, even the South Africans, probably don't know very much about that area. That's where it is if one looks at a map of the whole country. It's in the Northwest Province, where some of my colleagues here come from. These are the only two photos that I could find of Tosca, which is the archetypal one-horse town. And I think really quite appropriately for the South African context, the two pictures that I could pick up were of the liquor store and the church, which are the essential components of any town in the country. Now, in this particular area, the sole source of water was groundwater. There are some non-perennial streams that obviously don't run throughout the year, and water isn't used from those streams. So all the water is taken from underground, and this illustrates the water usage prior to compulsory licensing. The total amount of water that you'll see being used there is about 23 million cubic meters per annum, most of which is being used for commercial agriculture. Now, the reason for compulsory licensing, or perhaps one of them, seemingly the most important one, is that the current water requirements for the catchment exceed the amount of water available, which from a scientific point of view is obviously the best reason to go through a compulsory licensing process. But also the use of water for productive purposes in this particular catchment had been, and as you'll see later on still is, being used overwhelmingly by the non-disadvantaged. And for purposes of this discussion, what that means is white men. Now, through the allocation process, what the authorities had to do was to determine the reserve, and they determined the quantity for basic human needs, that amount that appears there on the screen. And their conclusion was that they didn't need to set any water aside for purposes of aquatic ecosystems, because seemingly there's no aquatic ecosystem underground. So they didn't consider that. The compulsory licensing process involved 60 applicants, 51 existing users, pretty much all white males or companies that are predominantly white owned. There were 9 new applicants, and of the total number of applicants, 21 isn't an additional number, it's 21 of the 60. 21 were historically disadvantaged individuals, HDIs, 2 of whom were black, which means that the other 19 historically disadvantaged individuals were white women. And then several juristic persons with members that were either or combination of HDIs or non-HDIs. Various special considerations taken into account in this allocation process. I won't go through those in detail because of time constraints, but clearly one of the important considerations that had to be taken into account was redressing the skewed racial holding of water rights in this particular area. Unfortunately, it wasn't possible to make significant inroads in respect of this because of the demographics of that particular area. There weren't that many black landowners in the area who subsequently became applicants. In a compulsory licensing process, the process talks of rules that are determined by the authorities in terms of which allocation is made. These rules are more in the nature, I think, of principles. These were the rules that were used in this particular case, the various considerations that pertained to different types of applicant, and then determined the amount of water that then would be allocated to these people. So you'll see there that in terms of Rule 2, the municipality applied for an allocation. The municipality owned, I think, 2 farms that they had purchased, I think, from white owners, where the intention was to use those farms to develop black commercial agriculture in the area. So they were regarded as the only black applicant and consequently given the full allocation that they asked for. Otherwise, other applicants were given a percentage of what they had asked for. And there had been clearly negotiation that took place in this process. So it seems that the holders of existing lawful water uses recognized that there was a problem, that there was not enough water to go around. And seemingly there wasn't very much opposition. As far as I can ascertain, nobody appealed against the determination, which is probably unlikely to be the case in future instances of compulsory licensing. So I think this was a fairly easy process, as these processes might go. And these rules then determined the final allocation, which I haven't put up on a slide, but the final allocation basically reduced that amount of water. You'll remember that the table that I put up earlier, roughly 22 million cubic meters to just over 10, which can be accommodated by the amount of water that was available. Now, just to conclude with some commentary on the process as illustrating, I think, wider issues relating to the interface between the right to water, the right to food security, the right to equality, and others. It's doubtful, I think, here that the transformation objectives of the water allocation reform strategy were met in this particular case. And I think the reason for that is because of the demographic issues that pertain in this particular area. Where this process is carried out in other parts of the country, it's unlikely that the same results will be met. And it might well be that the water allocation reform strategy takes a more important, or plays a more important role in future compulsory licensing situations. As I indicated earlier, the decision was that there wouldn't be any reserve determination for aquatic ecosystems, presumably because the thinking was there isn't any aquatic ecosystem underground. Nevertheless, the amount of water that was allocated took into account clearly that there had to be a certain amount of water left in the aquifer, which is a rechargeable aquifer, seemingly from the information that I could ascertain. So it wasn't the entire recharge that was allocated. So seemingly, aquatic ecosystems were in fact taken into account, even though the documentation indicated that they weren't. As I said earlier, basic human needs at the moment takes into account that people have a right to 25 litres per person per day. And the way in which this is determined distinguishes between domestic use and productive use. So clearly, if one's going to use that water for irrigation, 25 litres per person per day is woefully inadequate. In this particular area, it seems that a number of the people who lived there, which is a kind of semi-rural area, would have been needing water for productive use, not necessarily commercially productive use, but productive use for subsistence. And this clearly wasn't taken into account. So if one has to take into account the human right to water in order to be able to feed oneself, 25 litres per person per day is by no means adequate. And this highlights the interface between the right to food and the right to water, and indicates that implementing these rights in the context of this kind of legislative regime is very difficult. This is a fairly glib comments. Integrated water resources management in South Africa is on track. I'm not entirely sure what that means, but the policy certainly is aimed at integrated water resources management, and in some degrees it's being met. In other aspects there's still significant challenges, but ultimately the idea is that water will be managed in an integrated way, which requires, as most of you would know, consideration of land use and similar types of considerations that are not necessarily within the jurisdiction of the relevant government department, which is the Department of Water Affairs. There's clearly here an interface between transformation, the redress of inequality, food security, and the right to water. If one looks at those targets of water allocation reform, the idea is that 2024, 60% of water will be held by black rights holders. And at the moment, most farmers are whites. And there's evidence that suggests that through the land reform process, where farms have been passed from white ownership to black ownership, there isn't sufficient capacity to run those farms productively. And obviously one needs to address those kinds of concerns if those targets are going to be met. So it's not just about handing water over to black water holders, it's to ensure that that water can then be used productively, taking into account food security concerns. And I don't want to be misunderstood here as suggesting that black people can't farm. That's far from what I'm suggesting. It's just that clearly in South Africa that opportunity hasn't presented itself, and there will be significant capacity building that will need to be carried out. And as far as the right of access to water and progressive realization is concerned, the Mazabuko case is the case that was decided in the Constitutional Court. That obviously has particular considerations that related to those particular circumstances. The issue of the availability of water wasn't really an issue that was taken into account by the court. And that's not criticizing the court, I just don't think it was put on the table. But as Loretta indicated earlier, in many instances there will be significant problems in respect of whether there is actually the amount of water that's necessary to meet the right to water and basic human needs. So thank you very much. Any queries, if you don't meet me in the next few days, can be directed to that email address. Thank you.
I'd like to ask the speakers so answer some questions.
I was wondering if in any of your work, have you come across, particularly Jimena, in your case study of Colombia, have you come across cases and instances where the issue is not the quality of the water, nor is it the amount of water being received, but because of a lack of access, physical access to the water? That we know fresh water exists, potable water exists, but the population can't get to it because of either state action or action by other populations.
Well, the situation in Colombia is we don't really have a problem of scarcity of water. We actually have abundance of water. So there are not really cases talking about it, and the court has been very precautious in talking about quantities of water for a population. There is no case so far in which it grants us, like it's been done in South Africa, certain amount of water per capita, per person per day. So there are no information about it, and the court has decided not to mention anything about it. And the cases mostly are related also where you found the most difficult situations to access water are in rural areas, and mostly all the cases are related to urban areas. So there are not situations in which we can really see lack of access to water in Colombia.
Sorry, the what problem area?
Yeah, the problem is in rural areas, but most of the cases are related to rural areas. Sorry, rural areas is the problem, urban areas is the cases that we have now. Sorry.
Yeah, certainly when it comes to sanitation, there hasn't been, or I haven't come across any specific case law, but in terms of case studies, and when it comes to sanitation, they found that even in countries where there is an abundant supply of water, in terms of the water being there, the problem with sanitation is channeling that water through a wastewater and a sewage system and a water treatment system, that there is simply not the capacity, the financial means, etc. And so what then happen is people would simply use the water as is for sanitation purposes.
Just a brief comment. I think, again, I can't refer to any specific cases, but I think the thinking around the right of access to water in the South African context, and this would probably be a universal consideration, is that the right isn't the right to water as such, it's the right of access to water. And providing that right isn't necessarily giving water to people, but it's providing the infrastructure whereby they can access that water. So in South Africa, nobody can own water. So despite the fact that people are allocated water to use, they don't own the water. The water is, I think the ownership is a quite a difficult jurisprudential question, but no individual can own water in the country. So the right of access to water means the right to have some kind of system that gets the water to you.
My question is to Jermaine. You mentioned popular action in Colombia. Does it mean that popular action didn't ask for standing in this kind of litigation? Standing.
Popular action in this case is a specific group that can be identified that has been affected by the breach of a collective right. It doesn't have to be, for instance, the necessity to have a list of some cases, 25 people presenting, like for instance, a class action, but it's just an identifiable group of people that has been affected by the breach or potential breach of the collective right. That's how it works now.
I have a question about the framing of the right to water as the right to access to water. And I wonder what your thinking is in regard to those who don't have the ability to pay, and whether they have a right to water, government subsidized water.
Well, as far as I'm concerned, they absolutely do have that right, and I think the battleground, if you want to call it that, in the Mazabuko case, really revolved around that. I think economic concerns are important, and it's been universally recognized, I think justifiably, that water has to have some kind of value. But where one's dealing with people who are unable to pay for water, then some arrangement has to be made whereby those people can be allocated a reasonable amount of water, taking into account that one wants to have some kind of system where there isn't water wasted, which is I think far easier said than done, as one can see from the Zabuka case. But I think personally that case was very badly decided, with the result that there are significant numbers of people who don't have sufficient money who don't get that basic right to water as a result of that decision.
Well, the situation in Colombia is a specific one. We have the whole country is divided in social classes according to the resource that you have, and the class, like, we're divided mostly in 6 classes, and the richer people pay way more money for the amount of water they use than the poor people. So if for the same, like, let's say 100 liters of water, the class 6 paid 100 euros, the class number 1 only paid €1 or something. And the court has also said that there is no possible to create disconnection of the water if there is a situation where people is poor and they don't have sufficient needs to pay for it. However, unfortunately, as I mentioned before, it hasn't mentioned what is the necessary minimum amount of water to live without paying for that. So it just only mentioned it has to be, the companies needs to keep on providing sufficient water to provide for retail needs, but it doesn't mention a quantity. So it's still, we're protecting the right to water even for the poor.
I'm very interested in that notion because I struggle with this notion of a minimum core requirement. With regards to the Masibuko case, I understand, and the court didn't follow this route because the court doesn't use that as a standard for evaluating the right to water. But what I took issue with the fact that the court was basically saying, well, poor people cannot necessarily have this guarantee to water. But at the same time, because what the court had to deal with was the whole notion of a prepayment system for water. Whereas on the other hand, middle class rich people can buy water on credit. And for me, I take issue more with the equality, sort of the way the court has constructed equality in that case. However, I do think that minimum core is very difficult. Well, especially if you sort of set a specific target, and that's not always a target that you can maintain in a water scarce countries. So 25 liters per day, yes, but 25 liters per day when everybody's going through a severe drought.
I think that the people are waiting
I
say we would still have a great discussion, so they're fine with that.
Oh, yeah. There's another session starting again. But if folks want to stay and ask more questions, please feel free. And if you want to continue with your question, or...
Well, it's up to you. I mean,
if folks are
okay,
willing
well,
to stay to talk to
Maybe the session is in this room.
Oh, it's in this room session?
Yeah, that's why they're waiting outside.
I think it's probably.
Thank you very much.